It is time to connect these legal principles and jargons that I've been struggling to explain to you to the lessons that were learned by others in the courtrooms. And my prayer is that you wouldn't need to go through the courtrooms to learn those lessons, and that their stories should help you avoid the pitfalls that took them to the courtroom in the first place. Let's look at a case that was decided in 2019 by the Supreme Court of Nigeria. It addressed the question of the validity of a will that was purportedly made by Madam Adeline Kasumu, who passed away in 1955. Just look at the timeline between 1955 and the time the case was decided. The background facts are as follows. The central dispute actually revolved around the property that was located at number 19 Igbo Shere Road in central Lagos. It was registered in the name of Madam Adeline Kasumu, but her grandchildren, through her son Adetokunbo Kasumu, claimed joint ownership of the property, asserting that it was family property. Conversely, another relation claimed, who was a grandchild of the deceased, also claimed exclusive ownership based on a will that was allegedly executed by Madam Kasumu, which purportedly bequeathed the property solely to her daughter, Mrs. Roslyn Adeola Bruce, who was the mother of this grandchild that was claiming exclusivity. If her claim stood, Mr. Adetokunbo Kasumu will be disinherited. The issues the court had to determine included whether the will fulfilled the conditions set out for validity under Section 4 of the Wills Law of Lagos State. And secondly, the court had to determine who had the burden of proving the validity of the will, whether it was the person who claimed sole ownership or the other individuals who thought it was family property. This matter went all the way to the Supreme Court. The Supreme Court held that the will must be in writing, it must be signed by the testator, and must be signed by the witnesses in the presence of the testator, and vice versa, and that the signature must be made or acknowledged by the testator in the presence of at least two witnesses, contemporaneously, simultaneously. The court found that the will did not meet these requirements. Specifically, the will lacked the necessary attestation by the witnesses, thereby rendering it invalid. It was further decided that the burden of proving the validity of a will rests on the person who is asserting that the will is valid.